Good evening to one and all. It is my esteemed privilege to welcome you all to today's webinar hosted by the Sri Venkateswara Law Students Association. At SVLSA, our mission transcends many academic pursuits. We strive to foster an environment where legal education meets practical experience, empowering aspiring lawyers to navigate the complexities of the legal landscape with finesse. Since our inception, SVLSA has provided a platform for both learning and enlightenment through a myriad of activities ranging from legal webinars to interactive seminars. We have endeavored to bridge the gap between theoretical knowledge and real-world application. Today's webinar stands as a testament to this commitment as we delve into the intricate realm of intellectual property rights. Today, we are privileged to have with us a distinguished speaker, Dr. Mohan Dewan, a luminary in the field of intellectual property rights. With over 4 decades of experience as a practicing advocate, Dr. Dewan brings unparalleled expertise and insight to our virtual stage. His profound understanding of patent, trademark, and copyright law, coupled with his extensive experience as the principal of R.K. Dewan & Co., makes him a true authority in the realm of intellectual property rights. As we embark on this webinar journey, delving into the intricate nuances of intellectual property rights, let us seize the opportunity to expand our knowledge and deepen our understanding of this crucial aspect of law. Intellectual property rights serve as the cornerstone of innovation, creativity, and economic growth, playing a pivotal role in shaping the modern landscape of commerce and industry. So without further ado, I invite you all to join us in this enlightening discourse as we glean wisdom from Dr. Mohan Dewan's expertise and unravel the complexities of intellectual property rights. Thank you, everyone. And sir, the platform is all yours.
Thank you.
Please go ahead.
Thank you, Hari. Thank you. I'm now moving into presentation mode and sharing my screen. Okay?
Sure, sir, sure.
Good evening to one and all, and it's great to be part of this exercise. If at any point of time you are unable to hear or they're unable to see, please let me know, because we are all, both of us are dependent. I am in Pune, you are in Tirupati, so we are at a distance, and sometimes there may be technology failures, there may be some glitches. So please, if you cannot see, if you cannot hear, please do let me know, right, guys? So
Sure.
I'm trying to cover a vast topic that took me so many decades to study in a short span. I'm capsuling it within an hour, and I hope I would be able to do the job. And we will leave about 5 or 10 minutes at the end of this for question and answers, right? Intellectual property is something that comes or is created, as we know, from the intellect of the human mind. As of all laws throughout the world have defined that intellectual property is something that comes from the human mind. So it cannot come from any other living entity. It cannot, for example, come from the mind of your pet dog or your monkey or any other. And certainly not, as of now, the laws that we are studying do not allow intellectual property to be generated by artificial intelligence. there is a large controversy uh, about intellectual property that has been created by artificial intelligence. And so far, the laws have not defined intellectual property to be generated by artificial intelligence, because really the artificial intelligence is prompted. Prompts are given to that artificial intelligence to create intellectual property of different types. For example, copyright, trademarks, patents, inventions. They are all created by artificial intelligence using prompts which are human prompts given by at some point of time there is a human being that prompts that artificial intelligence to create intellectual property. All right. Uh, so what are the intellectual properties that we are going to cover today? Most of it we will be starting with patents, then move on to trademarks, deal with copyrights, and geographical indications. That is another important area in India. In India is blessed to have a very good geographical indications and industrial designs. These are the 5 aspects of intellectual property that we will cover, or 5 types. Now, this is my slogan that in this century, any company, or I would speak of any entity's future, standing will be determined by its ability to convert knowledge into wealth. All intellectual property is part of knowledge, the knowledge on the human mind, and using it creatively so that we can use it for social good. The law itself says that if there is some intellectual property that is created that is not for social good, then it cannot be considered as intellectual property by definition. Therefore, by definition, both as all these aspects are important: knowledge, creativity, and social good. If this is carried forward, if I am able to implant this into your minds today, how knowledge, creative, and social good, how all these 3 things are important, I would have done my job. This is the buzzword of this century: intellectual capital. He who owns that intellectual capital will be able to rule the world. And if you look at all the top 10 companies in the world, whether it is Microsoft, whether it is Google, whether it is Apple, their only blessing, even a company like Coke, their only blessing is that they have in this intellectual capital which takes them forward. Now, where does this intellectual capital come from? The source of all intellectual capital are human resources. In fact, Narayan Murthy said, every day, at the end of the day, my intellectual capital go home and they come back the next day. Now, where is this intellectual capital residing? It is residing in each one of you who are listening to me today, in your knowledge, in your skill, in your ability, and in your know-how. Your capital lies in all these, and this is a far richer capital than the wealth you may own, because using this capital, this is a renewable resource. Your bank balance may get, it's always great to have a good bank balance, but a bank balance can reduce, but knowledge, skill, ability, and know-how never reduces. It only improves and increases. Now, what are intellectual assets? That's another form of how intellectual capital from human resources is converted. There is a method of conversion of uncodified intellectual capital into intellectual assets. How do they become assets? Like plans, procedures, memos, sketches, and of course, intellectual property, what we are going to talk about. How does this happen? There is only one method by which it happens, and that is this. I'll just show you. It is by knowledge management. How do I manage knowledge? I convert this knowledge and convert it into intellectual assets by these arrows that you can see. Remember these arrows. These arrows are the method by which knowledge and know-how is converted into intellectual assets. And these arrows are nothing but jotting it down. You jot it down digitally, you jot it down on paper, you jot it out on diaries. Uh, uh, it has been said that in a day you get about 1100 new ideas. Mostly in the night. The night time is a great time to get this knowledge and know-how. And but unfortunately, much of the knowledge that we have, that we receive from the universe. This does not get converted or translated into intellectual assets because we don't use these arrows. We don't write them down. But sometimes you remember after 10 years, 15 years, 20 years, it has happened to me also several times. I remember, oh, this idea, I received this idea 10 years ago and I did not capitalize on it. Now somebody else, you read in the papers that somebody else has done an invention, created an invention, used a trademark, yeah, created some copyright or some piece of music. If you are a musician, if you are an artist, this drawing, this may have come to you 10 years ago, but what you did not do were create these arrows, which means record this knowledge and know-how. There is after something is converted to intellectual assets, there is a further arrow. The further arrow are commercial intellectual assets, assets that you can use. And one part of it is intellectual property, but a large amount of assets, which are for example, infrastructure, organization, roles, administration. These are also all intellectual assets. You get these ideas in your mind. They're not really commercial. They remain within yourself. They remain within the company. The way you do things, your roles, the technical processes, operating procedures. You don't really convert this into commercial intellectual assets, and they do not form part of intellectual property as such, but they are nevertheless intellectual assets, your intellectual assets as an individual, and your intellectual assets as a company or an entity or an organization. These are all aspects of intellectual assets which are worth something, which are extremely valuable for you as an entity, and they come by this knowledge management. Now let's take the word itself: intellectual property and right. I believe all of you are lawyers. Therefore, IPR is nothing else but a type of property. A property that is not created by bricks and mortar. They're not created by iron and steel, or by plants or wood or sand, but they are created by the human mind. Therefore, but they're as good as property. I mean, if one way to understand an intellectual property is to consider this property like being a house, like treat it as tangible property, or property that is like real property. We call that real property, and we call it intellectual property. Now it is therefore IPR stands for intellectual property and right. Therefore, just as you have a right on your scooter, which is a movable property, you have a right on your home, which is an immovable property. Similarly, you have a right on your on the creations of your mind, and this is what we call intellectual property rights. Remember, the word is intellectual. Intelligence is something that is inherent. Today, whatever lunch you must have had at lunchtime, that got digested by your intelligence. And now that has become part of you. You do not need any intellect to work. There is nothing that is intellectual about what you ate, what was converted to your uh, body cells. But that was intelligence, the native intelligence that is in your that is resident in your body. So that we don't call intellectual. The intellectual part are the thought processes that come from your mind, and that is where we find this particular right. Though there are rights created, and how these rights are created, we will try. I'll try and speak to you in the next 45 minutes. This is a tree, and of course, this particular slideshow for all of you. This is the share. This is something that I will share with you. You can keep, and any particular image that you can you would like to retain or keep. This is one particular intellectual property tree that I would like you guys to maintain, because this is where these are the different types of intellectual property rights that are available. For example, there are patent rights, trademark rights, copyright rights, geographical indications. These are all the types of intellectual property. So I call this the IPR tree. Now, since you are lawyers, you should know that these aspects, or there are some forms of intellectual property that we call statutory IP rights, patents, trademarks and service marks, copyrights, integrated circuits, the layout designs of integrated circuits, geographical indications, and plant varieties. These are all subject of statutory IP rights. When I say statutory IP rights, there are specific laws by which these IP rights are created, right? But then there is also another section which is called non-statutory IP rights, which means there is, as of now, these IP rights, they are intellectual property rights, but they are intellectual property rights not created by statute. So there isn't a law as of now. For example, a trademark, I don't need to register a trademark for creating a trademark right. Therefore, unregistered trademarks and unregistered service marks are subject matter of non-statutory rights. We call them the law. They come under the law of equity. They come under there are equitable remedies. We call that the law of passing off. And in those of you who have who have done who have studied equity, would have understood that there are these are unregistered trademarks. Similarly, trade dress. Similarly, rights against passing off. You have a right that your persona is not passed off. Recently, for example, there was a case of Mr. Amitabh Bachchan in the Delhi High Court, where his personality was being passed off. There is, for example, a notice just of Balasubramaniam, the late Balasubramaniam, whose voice has been copied by artificial intelligence, and that is then a new song has been converted, and that was by an organization called Kida Kola. They created a song in the voice of Balasubramaniam. So artificial intelligence is particularly guilty of this. The right that is violated by artificial intelligence in this case is the right against being passed off. You cannot pass off something as being somebody else or as the property of somebody else. As of now, in India, trade secret and confidential information is still a subject matter of non-statutory IP rights. Although there are internationally, many countries acknowledge trade secret. There are statutory limitations for using of trade secret and confidential information. Traditional knowledge. Traditional knowledge is the knowledge of our Vedas, the mudras, the various aspects, and Tirupati is rich in this traditional knowledge that is there, and this traditional knowledge is an important non-statutory IP right. Database protection rights and data exclusivity rights. Bills have been passed But as of now, both these rights have not come into the not become law. Finally, they are not yet a law, and I believe very soon we are going to have statutory based protection rights and data exclusivity rights. This is particularly very important for pharma companies and other companies who generate data, who need data for getting registrations of their drugs and pharmaceuticals or chemicals and fertilizers and insecticides. It's an extremely important right, and shortly this is going to happen. Now let's say for the next three topics that I'm going to take is, how do you recognize IP rights? Intellectual property rights are right around you. For example, this is the iconic cell phone, and the shape of this cell phone. Some of you may have seen this particular phone, but many of you may not have seen, because we are now in the era of smartphone. This was the original phone that was available, and the shape of this phone was a design right. Therefore, design right is concerned with the shape of this cell phone. If in your pockets you may have your own phone, and the shape of each different phone is a subject matter of a design right. Now come to the next. The circuit inside this phone at that point of time and inside each one of your phones are subject matter of patents, and a huge number of cases are being filed every day, virtually every day. On an average, there is one case of being filed of some phone company violating the patent of another phone company. Recently, if you see, there is a decision passed against Oppo in the Delhi High Court, where Digital Labs has filed a suit against Oppo for violating of their patents. So the patent, different aspect of their patent. So the internal circuitry, the internal aspects of this particular phone can be subject matter of patents. All right. Next, an integrated layout design of a chip within that particular phone can be is another IP right called IC integrated circuit layout designs. Then, of course, the iconic Nokia trademark. Unfortunately, this mark has now bitten dust, and Nokia phones shortly will no longer be available. But in the secondary market, Nokia phones are still there. But Nokia, the use of the word Nokia on this phone is a trademark that was probably at one point of time. I may share with you that as of today, even until today, the largest number of phones, people think of Apple and Samsung and LG and Oppo and Huawei and Xiaomi, but the largest number of phones that were ever sold and the largest number are Nokia phones. Even today, they still maintain the record of having the largest number of phone sales in the world. Now, the sound that you heard was subject matter of a sound trademark, and the music, that the notation of these sounds, if I convert it into notational, is subject matter of copyright. So in a single device, you have all the main intellectual property rights. I don't have to go far. This probably is there in the pockets of each one of you who are hearing me today. Take another. You see an ad. Now I would want you to look at an ad, and from that ad, any ad that you see, and try and do what I'm doing now, is to identify the intellectual property rights. For example, the seat of this bike, the flame bike, is subject matter of design. The special seat which was profiled in this particular way is subject matter of design. The slogan, flame soon on the roads to turn heads and set a million hearts aflame. This aspect, these wordings, this text is subject matter of copyright. Nobody can use these same words for describing this particular vehicle. Then, of course, the twin cylinder engine, the cylinder, the engine of this is subject matter of a patent. Then, of course, the trademark TVS with the flying horse, I would call it the galloping horse, is subject matter of trademark. So remember, in a single ad, you can see, you must visualize, and hereafter when you see an ad, please identify these various features. Let's take another example of a car. All right, this is a Hyundai car. All right. Now, of course, here this text that is there in this ad or in this on the screen here, this is subject matter of copyright. You cannot use the same wordings. You cannot copy the same wordings, cover every mile in style. And the wordings that were there, this was created in 2022 by Hyundai, and this is subject matter of copyright. Okay. For example, the design of the hatchback in this particular car was subject matter of design. So it's a design right belonging to Hyundai. Then Hyundai Kona electric that was there, and the Hyundai emblem, these were subject matter of trademarks. Then all these aspects, the flow or the flow element on the front fender, the wheel, the lighting devices, the backlight, the ECU on the board, these are all subject matter of patents, right? So in a single ad, you can identify different intellectual property rights. And this is something, ladies and gentlemen, extremely important for you to do so. Now, since you are lawyers, this is just a compendium of the various laws that govern different intellectual property rights. And of course, these slides I will share with you, so you can, if anybody is interested in a particular right, please please study those rights, and then if you have any difficulties, please share them with me. All right. Now, where are intellectual property rights administered? They are administered at the intellectual property offices throughout the world, and in India, we have the Office of the Controller General of Patents, Designs and Trademarks, which is an office located in Mumbai. And under this, the various intellectual property rights offices are there. There are different branches. There are your closest branch is Chennai. If you create a patent, you will have to file the application at the Chennai office. A trademark will be also at the Chennai office. Geographical indication also at the Chennai office. Design right at the Kolkata office, right? This is the trend. As you can see, even with the close of 23, which latest figures are available, there were 6 lakhs intellectual property rights were created in the year 22-23. So we have a huge number. India is now ranking almost fourth or fifth as the largest filers of patent applications. So creativity, as you can see from 18-19, every year it is growing into a substantial figure. Even designs are growing, trademarks are growing. Each of these intellectual property rights are growing year to year. As this is a buzz sentence. How do you predict the future? You can predict it by inventing it. And an inventor is such a person, I would say, who qualifies to be an inventor. He does not live by the rules, he creates them. Now, this part I will need to rush through in the next half an hour to explain to you what are inventions in India. Inventions can be granted for new products or new processes. They may have an inventive step, and they ought to be capable of industrial application. That is the only thing that I need. A new product, it must be new. It must be new for the first time in the world. I can't say that it is new in India. Something I get from Korea and say that it is new in India. I cannot. And it must have an inventive step. There must be something intellectual about about the product or process that any other common person could not have identified it, either product or process, and it should be capable of industrial, which means something that I create artistically or I create manually cannot be considered as an invention under the Act. These are examples of different times: pharmaceutical drugs, processes for making these drugs, telephones, artificial intelligence, mechanical devices, the pen drive, for example, different areas. So these can be subject matters of patents. Processes, products. Remember, new product, new process. If it is new, I can get a patent and capitalize on it. But important thing is that I must go and rush to the patent office first before I disclose that invention to any person. Before I disclose the product or process, put it in an exhibition, inform your friend, or do anything of that nature, because newness then is lost. It is, you may be considered as an inventor, but there is no patent available because you have yourself disclosed that product or process to somebody else. What do patent rights give you? Patent rights give you the right. They are not they are considered as a negative right. They give you the right to stop other people from using, selling, or importing the patented product or process. All right. Now remember, patents are territorial, which means you have an Indian patent, a US patent, and you have to file patent applications in each country. And because they are considered as property, they are transferable, which means they may be licensed, sold, assigned, billed, transmitted. Now, the term of a patent is 20 years from the date of filing of the application. So after 20 years, the invention becomes common property. All right. Now let's move to the next right, a trademark. A trademark can be a sign. These are all examples of trademarks. HP, and you will see a sign when the mark is registered. We see a sign which says that the mark is registered. It's a sign. Microsoft, McDonald's, Apple, HP. These are all trademarks which can be logos, pictures, word. For example, the M logo, the two arches, the word Apple, HP, National Stock Exchange, NSE, for example. Now remember, this trademark is an unlimited right, but it needs to be renewed every 10 years. Now, there are different types of trademarks. For example, Times of India is a word mark. Armani's logo is a label mark. Porsche, the logo Porsche is a label mark. House mark, for example, the House of Tatas. This becomes a house mark because it is their mark of the house. But they are all trademarks. All of them are trademarks. Then you have you can use a crocodile, for example, you can have a living device or a non-living device like anchor. For example, monogram, our office, the monogram that you see on this slide, RKD, is a trademark belonging to that's called a trademark. The letter mark are marks like GTC, Golden Tobacco Company, GTC, these would be considered as letter marks. LG is a letter mark. Invented words are, for example, Kodak. The word Kodak is an invented word. Then coined words, Amul, For example, this was a coined word from Anand Milk Union Limited. They coined the word and made it Amul. Now, Hilton and various the strongest marks. If you have a unique surname, then that can be subject matter of for example, Kirloskar, Gillette, Colgate. These are actually all surnames. Hilton, for example, is an example here of a surname. Then, of course, personal name, Praveen, can be subject matter of a trademark. Now, portrait marks, which means the picture of well-known personalities. For example, here is a picture of Sanjeev Kapoor, the well-known chef. That can be a trademark. And then you have, for example, also descriptive marks. They are marks. They are descriptive marks, but they may not be registrable. For example, the words "really good." This cannot be subject matter of a registration. Although I can use "really good" as part of a trademark, right? So there is another area of trademarks which are becoming extremely important. They are called sound marks. For example, sound marks are the actual sounds that you hear. In the era of smartphones and in the era of OTT platforms, sound marks are an important example. For example, the MGM lion, the roar of the MGM lion, the 20th Century Fox fanfare mark, the Sweet Georgia Brown basketball team. That can be subject matter of a trademark. Intel's, for example, Pentium, it has the 3-second chord sequence which it uses. The three ting ting ting, that is Intel's trademark. These are all sound marks which are extremely important nowadays. And I would just remind you that these sounds can also be important sound marks. All right. Lately, for example, scents, the smell of different, for example, a thread, furniture, fragrances. These can also be considered as trademarks. Even scent, a particular scented product can be considered as a trademark. All right. Three-dimensional trademarks, for example, the contours of a Coca-Cola bottle, the Toblerone chocolate, the triangular Toblerone chocolate, the Super Cub scooter of Honda, for example. These are examples of trademarks. And the Royal Salute whiskey bottle shape. These are all what are called three-dimensional trademarks, and many of them have been registered as proper trademarks. So it's important to understand that the shapes of products can also be very important trademarks once they become iconic. Let us move to industrial designs. Industrial designs they relate to the external appearance of an article, but they are industrial designs which are again need to be new. They need to have some eye-catching and visual attractive features, ornamental aesthetics, and only relate to the visual aspects. They are not, not the contents. They only relate to the mechanical working of the article. They relate to the shape of the article, and they need not be associated with any product or goods, or any particular producer of goods. They don't need to be associated. They are industrial designs, so they can be created by generally designers. Now, for example, here are examples of 4 chairs. Each of them are subject matter of a separate design. The color combination of the chairs, the shape of the chairs. There are 4 different chairs that I have picturized here, and each of them are subject matter of an industrial design. Remember, for protecting an industrial design, I need to register the design first, and only then I have the right for an industrial design. These are designers who create these designs and then register these designs. For example, this textile design or the design of a bottle, these are all subject matters of design registration. The term of a design, any of this industrial design is again for a period of 15 years. And they must be industrial designs. They must be capable of being applied on devices by industry. For example, if a carpenter is making that particular chair, then it cannot be considered as an industrial design. It must be made not manually, but by an industrial method. Only then it can be considered as an industrial design. All right. Now come to the next. Copyright. This is probably the among all rights. This is I would say the truly intellectual, because original literary works, artistic works, computer programs fall under literary work. These are all subject matter of copyright. Any paper that you write, for example, the Ram Mandir, the whole structure of the picture of the Ram Mandir, it is subject matter of copyright. It's an architectural work. Musical works, computer programs, any sort of the written notations of music, a drama, a script that you write, all these sound recordings, for example, on the pen drive, and these are all a cinematographic film. These are all subject matters of copyright. And the largest number of cases that are in the world relate to this subject, this IPR, which means violation of copyright. And particularly in the age of artificial intelligence, this is going to be the right that is going to be the most violated in the future. The term of a copyright is 60 years. Now, this, for example, in the case of an author, it is counted from 60 years following the death of the author, and therefore this is important to understand. Literary works, dramatic works, musical works, artistic works, and in respect of other types of works, they are 60 years counted from the date of publication. For example, posthumous works, anonymous works, sound recordings, photographs, cinematographic films. This is 60 years from the date when they are actually published. IC layout designs. For example, the integrated circuits, those of you who are interested in, this is of course the least utilized intellectual property right in India. The layout designs, the way components are mounted on a circuit board, become subject matter of IC layout design rights. But it's important to know that this is a right that is available in India. Now, this is an extremely important geographical indication. There was a major controversy surrounding your area. For example, when the Tirupati Laddu, the Laddu of Tirupati became a geographical indication, it was subject matter of great litigation at the Chennai High Court. And eventually, finally, the Devasthan won. And only the Laddus that came from Tirupati could be considered as geographical indications. Other laddus that they were copied, and other laddus could not call themselves as the Tirupati laddu, because they did not originate from Tirupati. So geographical indications are really what is called an uplifting. They uplift certain areas. For example, they are signs of quality. They must be of they must originate firstly from a particular geographical origin. For example, Tirupati. They must be of a particular quality. There must be some reputation that has been associated with this, and certain characteristics which can be attributed to that place of origin. So that is why only those can be considered as geographical origin or geographical indications. For example, the Darjeeling tea, that was a geographical indication. The Mysore silk, for example, that is considered as a geographical indication. So remember, these are the goods that can be included: agricultural goods, natural goods, which means goods that grow in a particular area, goods that are manufactured in a particular area. For example, electric motors. Coimbatore Coimbatore motors are supposed to be is a geographical indication for motors. Handicrafts. And this is one area which respect the handicrafts or industry in a particular area or a foodstuff in their area. And this is a permanent right. It needs to be renewed every 10 years. Now, this right is one right that is not given to individuals. This is a right that is given to an association of creators in that particular area. For example, was all people growing Darjeeling tea in Darjeeling, producers would be entitled to use the Darjeeling geographical indication. Mysore silk, all silk weavers in Mysore only can call their silk as Mysore silk. Now, for example, in Kolhapur, there are slippers. Kolhapuri slippers were an important part. Basmati rice was given a geographical indication because it grew in a very specific territory. And so on. For Kolam, for example, Kolam rice was given a geographical indication. Andhra is a particularly, for example, Pochampalli, saris, and in Bengal, the Bengal Rasgulla, and Bengal Rasgulla, and recently a kind of peda. The Dharwad peda, peda from Dharwad was given, and Rasmalai from a particular territory was given. Now, what is the importance of IP? These are the last few slides that I'm going to share with you. Remember, every business cannot grow, cannot come into existence if it does not have some form of IP. They are not just businesses that deal with technology, not just businesses that deal with products. Every business has some form of intellectual property. Without that intellectual property, a business cannot come into existence. It may be either trading in an intellectual property, or the product that it trades in will have some intellectual property. The product it creates may have some intellectual property. So for example, the typical first thing that comes to mind are brand names. The name of every business, even a pan shop or a supari shop next to your college, for example, the college itself is the name of the college is an intellectual property. I have made, for example, recently ILS. I made it a well-known trademark, the ILS college in Pune. Similarly, your college, the name of your college can be intellectual property. You are studying in an institute which has intellectual property. Now, any innovative products, the methods of manufacture can be or may be protected by patents. But you must be aware that this patenting aspect is available. In India, almost 5 lakhs intellectual property rights and patents are lost every year at the MTech level. People do not file these patent applications and they are lost in India. The visible appearance of the product that you are either selling or marketing or manufacturing can be subject matter of design. And overall, everything that you are writing, everything that you are creating, every signboard that you may have, every manual that you may have, your layout of your shop, the layout of, they are all subject matter of copyright. Therefore, it's extremely important to understand that no business can actually function without some form of intellectual property. All right. If this aspect is understood, I am now throwing this open to any questions that the audience may have. Mr. Krishnan, anything that the participants, anybody can ask a question? Yes. Sneha, please go ahead, unmute yourself and please ask your question, Sneha. The host, please give permission to the person.
Sneha,
Yeah.
yes, sir. Sneha can unmute herself, sir.
Sneha, please unmute yourself.
Good evening, sir.
Good evening. A little louder, Sneha.
Good evening, sir. Am I audible now?
Yes, you are audible.
Sir, first of all, a very insightful content and presentation.
Thank you.
So I have certain doubts regarding the trademark. You told about different types of trademarks, right?
Yes.
So in that, I could not understand about the house mark, device mark, and very specifically the descriptive one that you talked about, which is not registrable.
Yes.
So these three I could not
All right.
understand.
Excellent question, Sneha. See, a house mark is also a trademark. There were all types of trademarks. See, there are different houses. For example, Tata is a house mark that is used on whether it is a Tata Motor, Tata Power Company, Tata. So these are house marks, and the Tata mark is not owned by any of these companies, but it is owned by Tata Sons Limited, which is the house of Tatas. So they will be owning the house mark. So it is a trademark, but it is generally an umbrella mark for various entities that are going to use Tata Consultancy Services. Tata Consultancy Services doesn't own the trademark Tata. The Tata House or the House of Tata, which means Titan, whether it is Titan, whether it is Chroma, these are all segments of the House of Tatas, and they are considered as house marks, and not exactly they. But even a house mark is a trademark. For example, Tata Sons Limited registers the trademark in its name and licenses this trademark, this house mark, to its various entities. So that is the house mark. Now, the way Tata uses the trademark. So for example, Aditya Birla can also be a trademark. Birla can be subject matter of the Birla trademark. That is the House of Birlas. Jindal's trademark is another mark. Kirloskar's. These are all house marks. Now you may have company brands. For example, Novartis. Novartis is a house mark belonging to Novartis. They don't have a product under the name. It is the name of the company which becomes, and so this is it is a Novartis product. This is a Mahindra product. This is a TVS product. So these are all subject matters of house marks. Now the device mark is a device mark. For example, Anchor is a device mark. Crocodile is a device mark. Crocodile is a living device mark of a living animal. Anchor is a device mark. Kangaroo, for example, for staplers, is a device mark. So these are device marks. And marks which are descriptive. For example, anybody can call their product tasty. Tasty, spelled in that word, or good, or really good. These are marks that cannot be considered as registrable. So that you cannot stop somebody else. You may call your product really good, but then these are descriptive marks and they are not registrable as trademarks. Yeah. All right. I hope I have been able to and if you can, I will, of course, the management will share my email ID. So if there are any questions that you may have, you can even share it with me offline. All right, Sneha?
Yes, sir. Thank you so much, sir. So one more question I have. Can I ask?
Sorry?
Sir, I have one more question. Can I ask?
Yes, please. Go ahead.
So it is relating to copyright.
Yes.
So you said that it is there is 60 years term for the copyright.
Yes.
This is basically for the musical work and some more works with it.
Yeah.
So it was mentioned that the 60 years starts from the date of death of the author.
No, that is only for literary works.
Okay.
That's only for literary works. You're a writer or a music composer who actually so musical work is written notation. but let us say a cinematographic film, the right starts from 60 years from the date the film is published in the it is made. When you say published, means made public. The first time it is made, launching of a movie, 60 years from that date you have to count as far as a film is concerned. The first time a song is a recorded song is played in public, 60 years from that date you have the musical work. But the author or the music composer, when he composes, it is 60 years from the date of the composition of his music. But so a musical work is slightly, it is the notational music, not the song. So a song may lose its copyright in 60 years, but if the author is still alive, or in the artist is still alive, then it will be 60 years from the calculated from the death of the author. It's slightly complicated, but that is how it is calculated. For example, take it from the author, a person who writes a book. Now, 60 years after the author, let's say Rabindranath Tagore wrote Gitanjali. Now, 60 years after Rabindranath Tagore died, the copyright in that Gitanjali is lost. Of any picture that is made, these are all 60 years from the day when the photograph was first published. All right. Okay, Sneha.
Sir, I have.
Go ahead, sir.
So what role do IPR play in incentivizing creativity and entrepreneurship in India? Because we have this AI era which is going on.
Yes, sir.
What type of role does IPR play?
Intellectual property rights it plays a pivotal role, because artificial intelligence cannot create rights. It can only duplicate rights. It can only copy rights. Just now in the case of Balasubramaniam, each note of his voice had copyright. And his voice, the copying of his voice was can be subject matter of a litigation, and it will maybe eventually the matter may be settled, and the estate of Mr. Balasubramaniam may give a license for a particular fee. But it's in this era, it is going to play probably the only way that's going to separate, the only right available to artists, to writers, is intellectual property right. Therefore, it is going to play an extremely pivotal role in the future, and artificial intelligence will not be able to overcome this copyright law, or the patent law, or the trademark law. It is not going to be able to. I cannot get counterfeit products in the marketplace without violating trademark law. So it's going to play a pivotal role, sir.
Thank you, sir.
Last question, sir. Last question.
Does anyone have any last questions they can ask?
All right, sir. I think we can stop now.
Okay, so sir, I think Mr. Mokshan Reddy have some question.
Okay, ask him, please.
Sir, I would like to ask in offline.
Okay, please ask offline. Thank you, sir.
Sir, mail ID, sir.
Mail ID. Can you
I will share mail ID with the.
Yeah, please share my mail ID with all the participants, and I will then certainly help anybody who has a question. We will certainly help out.
Thank you, sir.
Sure.
All right. You can share my cell number also. My cell number is my WhatsApp number. You can send me either a WhatsApp message, or you can send me an email. I will certainly answer each and every question that the students may have.
Thank you, sir. Thank you, sir. Have a great day, sir. Thank you, sir.
By vote of thanks, we will end the session, sir.
Yes, sir. Yes, please go ahead.
Okay, sir. Hello, everyone. On behalf of Sri Venkateshwara Law Students Association, I extend my heartfelt gratitude to everyone of you for your active participation and valuable contribution to our webinar on intellectual property rights and overview by Dr. Mohan Dewan.
Thank you, sir.
We are immensely grateful to Dr. Mohan Dewan for sharing his profound insights, and expertise on this crucial subject matter. His comprehensive overview has undoubtedly enriched our understanding of intellectual property rights and their significance in today's world. I would also like to express my gratitude to all the attendees for their enthusiastic participation, engaging questions, and valuable contributions to the discussion. Your active involvement has made this webinar a resounding success. Furthermore, I extend my appreciation to our founder and President K. Pavan Kalyan and everyone else involved in making this webinar possible. Your hard work and dedication are truly commendable. As we conclude this session, let us carry forward the knowledge and insights gained today and continue to promote our awareness and understanding of intellectual property rights in our perspective endeavors. Once again, thank you to everyone who made this webinar a success. We look forward to your continued support and participation in future events. Thank you, sir.
Thank you. Thank
for
you.
the enlightenment.
Thank you so much, sir. Have a good day.
Thank you.
హరికృష్ణ గారు మెయిల్ ఐడి కొద్దిగా షేర్ చేస్తారా?
జస్ట్ నేను చాట్ లో షేర్ చేస్తాను. జస్ట్
ఓకే అండి, థ్యాంక్ యూ.
వాట్సాప్ లో పంపించాం ఆల్రెడీ, చూడండి ఒకసారి.
మోక్షన్ గారు సార్ చాట్ లో చేస్తారు, మీరు గ్రూప్ లో పెట్టండి ప్లీజ్.
ఓకే అండి.